Welcome to Family Law Matters, the podcast presented by the Mealy Firm. Visit www.allfamilylaw.com or call 866-687-8561 to learn more. And now, here's your host.
Hey, welcome in. This is Bill King with another episode of Family Law Matters. And today we're going to talk to you about how to not get in your own way in a family law matter. And I'd love for my colleagues to go around the table and introduce themselves and say hey to the listeners.
Hello, my name is Julie Watkins, and I'm the paralegal manager for the Mealy Firm.
Hello, I am Caitlin Hawker, and I'm an associate attorney in the Marriott office.
My name's Jeff Wilson. I'm the Chief Financial Officer for the Mealy Firm PC.
All right. Well, welcome back. Continuing along that notion of vengeance and the two A's that you said, alimony and attorney's fees. A lot of clients will get stuck on this notion of, and like you said, Julie, my friend got alimony and it was $3,000 a month for 10 years. I want the same thing. And I'm like, well, you were only married for 3 years and you make more than him, right? Or, well, okay, I hear you. You're married for 10 years, you're married for a lot longer than 10 years. You have a long marriage. He worked, but you all are making similar amount of money. Or I want alimony and that's all I want. And if I don't get alimony, then I've lost this case. Well, again, you go back to that notion of, well, there's no win or lose. What we're looking for is justice and to make you whole, or to make both of you whole, or to get you both through this process in the best possible way with the best possible outcome. And so thinking through, we've got to be creative. We can be creative. And hopefully that client can come in, or you can work with that client to find that mindset of reaching a resolution amicably and being creative through the process, and also helping them transform through the process. So I agree. A lot of clients will get stuck on buzzwords or these magic words. And if you don't get exactly that, then that's it. I'm done. And so good client expectations, 100%, and being creative and understanding that one can equal the other. It doesn't necessarily have to go by the same title or be, listed as the same thing. Like you said, instead of getting 50% of the house, you get 60% of the house, and that is another $100,000. And if you were asking for $100,000 in alimony, you're getting the same exact thing. So it's a win-win. He or she is not paying you alimony, but you're getting the same amount. So in their mind, they've won, and quote unquote won. And in your mind, you've quote unquote won. But what's really happened is you all collaborated and came up with a resolution that suited you both, such that you both walked away from this process feeling whole and satisfied with the outcome of the process. So great point.
Another thing that I think I've seen and I've heard is that sometimes we have to rework parts of cases because there was not initial full disclosure, and there wasn't truthfulness. There wasn't full disclosure. There may have been a disclosure of an asset, but not of what the value of it was. And that causes strategies to have to be reworked and more case time, and that's another way to burn money.
Yeah, I agree. And that's why I always emphasize with my clients is from the first meeting that we have that everything they tell me is confidential. I will say at mediation, that is a time where you need to fully financially disclose because it's required at mediation, and clients need to be prepared to have all of their assets ready to be disclosed to the mediator. But for example, with cases with infidelity, I would much rather know from day one that there's been infidelity than 6 months into the case and someone tell me, hey, I have a girlfriend. And I'm not here to judge you. I am here as a counselor, and a counselor can be different hats on different days. Of course, as a lawyer, I am your advocate, but also sometimes, I put on my therapist hat and I'm willing to listen to what you have to say. But with those hurdles in divorce cases, I'd much rather get on top of it. And it is confidential. So I would much rather have a client be candid with me about those kinds of issues.
Yeah. You don't want to meet the girlfriend in the courtroom.
No.
Well, I've known in past cases that I've helped out on, if there is something that the client has that's a disclosure that's not favorable, our strategy sometimes is to put it out there right away. Your Honor, here's this, he had an affair. Let's put it out there right away. It has less of a shock factor if we put it out there first than for opposing counsel to go, well, Your Honor, he had an affair. If we go out there and say, yeah, he did. But here's, it's not as big of a shock factor if you admit it and you bring it out there to start with. We're on the offensive with it. We're not on the defensive with it.
Mm-hmm. Yeah, there's a case that I've heard about within the firm. I don't want to say the attorney or the names, but the story goes both parties were doing drugs and there were children involved. And they went in and the other side was up in arms about our client being on drugs. And there were drug tests that were done and our client had tested positive. And so the strategy was to walk into court and say, yep, Your Honor, he sure did. He understands he messed up. He's committed to being better. He's committed to doing better. And we'd also like for mom to do a drug test. And mom was swearing up and down that dad was doing drugs and she was the better parent. And mom went and got a drug test and tested positive. And so the judge, looking at that, said, I really appreciate your honesty and being candid about your situation, looking at, dad, and was furious that mom had lied. And so to that point, laying out the bad things, taking your lumps, and then understanding how to move forward, excellent, is just, I think, the way to go. Because like you said, you take the wind out of opposing counsel's sails. You don't have that aha gotcha moment, that it's very anticlimactic for the opposing counsel if you say, yeah, he did bad, she did bad, she did this, he did this. But look at, you start here and you go up, right? Instead of going up, 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 and then all of a sudden you get to the end of the trial and then boom, you're back down at the bottom. And then you're on, that bad side. I won't say losing side or winning side, because again, you're not really, we don't try to look at it like that, or we're not, looking at it from that kind of context. But you've suddenly lost credibility. You've suddenly lost a lot of momentum that you had in order to get to where you wanted to go. So, yeah.
All right. And you're not going to shock your attorney any more than you're going to shock your doctor.
Yeah, I agree with that. And it's when I have potential clients and clients sitting in my office, I agree. One of the things that they can get in their own way is not being honest or forthright or truthful. You said, I don't want to find out about the girlfriend at trial.
Right.
I don't want to find out, and this happened to me, I don't want to find out about kids that you have at trial that I was not aware of for 6+ months that are now involved in this case. And so, yes, being forthright and laying everything out there, because it is a judgment-free zone. I am there to help you. I'm there to provide guidance. I'm there to provide advice. And you're going to have to say something so off the wall for it to be something that I've never heard before, let alone surprise me. I meet with clients daily, multiple clients daily, and I've done that for 14 years now. And I've heard some great things from great people and harrowing moments, and where people have stepped up and just amazing things from clients. And I've heard some real dark stuff from clients, that gambit of things. But through law school and through this profession, we are taught to be consummate professionals and to do and to advocate, but not just advocate, zealously advocate for those clients, right? And to have honest discussions with them about the impact of the law on their cases, regardless of good, bad, or ugly.
Yeah.
So all right. Any other, other things that clients get in their own way with that we can help them say, just stop so we can help you move forward?
Using the children as part of the divorce and using children in a pawn situation of, well, I'm going to control the narrative of this situation by controlling the child or the children. Oh, he's not doing this, so I'm going to not let him have visitation. Or you're weaponizing your children against your spouse.
Yeah, absolutely. Absolutely. I see that all the time. That also makes me think about, and it's funny, I hear these things and I jump to cases and I'm like seeing cases play out, the cases that I've had. And so I start playing them in my head and I start thinking about, oh, that happened in this case and this happened in that case. And so one of the other things that I would say is, I think just on a simplistic level, stubbornness, but the unwillingness to hear another person's position and be coachable on that position or what's going on in that situation. And what I mean by that, when you say using children as a pawn, what I think a lot about is, I'm a parent, and sometimes I can get stuck in a position of, well, I'm their parent and I know what's best for them. But that is not always the case. And a lot of people think if I admit that I'm their parent, but I may not know what's best for them, that's failing as a parent. And I completely disagree with that. And my position on that is I'm good at some things, but I'm not good at everything. And so there are going to be things in my children's lives where there's certainly going to be somebody out there that's better at that and that can help my children more than I can. And to me, that is the opposite of failing. That to me is bravery, to say, I need somebody else to come, the funny, immediately I think I'm like, math, boy, just please don't even, I'm going to need somebody to come and tutor, or science, like science and math. And, I think that seems kind of cliche. I mean, we're attorneys. We didn't go to med school. We're not scientists, but, I also think like sports. Yeah. I grew up playing sports, but I grew up playing baseball. My son has been talking to me about wanting to play basketball. I know basketball. I watch basketball, but I am not educated in understanding the inner dynamics of becoming good at basketball. So if he were to develop that, passion for basketball, I would want to bring somebody in to help him with basketball. And I wouldn't be stubborn about, well, I'm his father and I've got to do everything. And I've got, so where I see some clients kind of getting in their own way is that stubbornness of, I know what's best and I refuse to see any other position than that. And guardian ad litems and judges pick up on that. And that goes to the direct factor, in my opinion, of co-parenting. Like, are you willing to see the other person's side? Are you willing to concede that it's not your way or the highway, right? So.
Bill, could you explain the guardian ad litem thing for the audience? That's something that many people probably don't even know what that is. And that's something that before you even go into a divorce with children, you should know that exists and that can't happen. So can you explain what a guardian ad litem is?
Yeah, I'm going to have Caitlin help me with this. So I'll start with, a guardian ad litem is a quote unquote expert who is appointed by the court to represent the best interests of the children. And that can be requested by a party, that can be requested by an attorney, or the court can, of its own accord, appoint a guardian ad litem. And they are utilized in custody cases and some visitation cases, but they're utilized in cases where children are involved to represent the best interest of the children.
Yes, and so going off of that, sometimes guardian ad litems are assigned in a case automatically by the judge, but often we will make a motion for a guardian ad litem. Guardian ad litems can be specifically useful when there's very conflicting stories between parents, and we need to know what the truth is, as much as truth exists in that context. But also, my client has a very different version of the story from opposing party. And, I believe my client, I trust my client. And based off what she's told me of how the children react to her versus him or him to her, there's a need for a guardian ad litem there, especially if the children are more aligned with one parent over the other. This specifically comes up in cases where both parents are in the same state. Sometimes I'll get a guardian ad litem if one party is in another state. But typically we use them in situations where there's joint physical custody. For example, mom has 1 week, dad has the next, with there's significant time between the parents.
Or if they're looking for joint custody or something along those lines, or both parents are arguing for custody. If one parent is saying I want custody and the other parent understands they have a difficult working schedule, they're traveling a lot, and they are rational and reasonable, they'll say, I certainly understand. I would like as much time as possible, but I'm not arguing for primary custody. It's usually, I say fairly easy, relatively easier in those cases to resolve custody disputes than when both parents are arguing for custody. And those, I agree 100%, are the cases in which parents, their counsel, and or the court need more insight into what's going on in the situation to help understand and help come up with, argue, and for the judge, order what that custody and parenting time looks like. And the reason for that is, and why, and really what this was born out of is the court does not have enough time to do a thorough investigation of what's going on in the case. I mean, you have 10 years of marriage, 5 years of marriage, 8 years of marriage, 25 years of marriage, and you've got everything that falls within those years of parenting, of working, of, fill in the blank. And then you've got a half a day or a day or 2 days to explain that to a court. The guardian ad litem functionally is able to do a lot more investigation, go talk to teachers, go talk to friends and family, review more documents, such that they can develop and then deliver to the judge in a succinct fashion more of that history, so that the judge has a better understanding of what has happened, to be able to, within the context of custody, not financials or anything, but within the context of custody, to be able to make a custodial decision. And that, I think, is the premise of that, and the thoughtfulness behind that is excellent, because you're giving the client more of an opportunity to tell their story, as opposed to being limited to this. Now, functionally speaking, when you're in court, you do have half a day or a day or 2 days, but all that time leading up to it, they have somebody who is an extension of the court that they are able to relay their experiences, to feel heard, and to advocate for their side through them and their counsel, and then go to court and help come up with a resolution.
Yeah, and I think that this in some ways touches on that mindset part, because if you go into these proceedings with the mindset that this is just it's a he said, she said, and I, as the he, I win every time because I talk so well and she doesn't. When you go into that thinking, I'm going to win this, not realizing that it's not a he said, she said. The court or the opposing party can tag in a guardian ad litem, and now you have an impartial observer in the middle of it. Are you willing to do that?
The other great thing with the guardian is it gives the children a voice. For the most part, children aren't allowed to testify in court. It gives the children someone to talk to and give their opinion and give their side of things. So it gives your child a voice.
Yeah, absolutely.
And it's not just your narrative or your dad or the dad's narrative or the other party's narrative. It's the child's narrative. And it gives your child a voice.
Well, wrapping up things, again, we've been here talking about how to not get in your own way in a family law matter. Are there any final thoughts that you want to leave our listeners with in just saying, hey, stay out of your own way, trust your attorney, keep the faith, and go forth and transform and be happy on your new path in your new life.
Yeah, I mean, I think that the key to staying out of your own way is to know what the way is, to scout this out, to know the possibilities about what could the court do, and be willing to deal with that. And if you know how that works and how your attorneys work, you can stay out of their way and stay out of your own way.
And that's why I think from the get-go, finding a firm that fits you is very important from the get-go. And so for our firm, we very much specialize in customer service and customer care. And so if you want someone to zealously advocate for you and be there every step of the way, then we would be a good fit for you. And so I think finding that firm from the beginning is very important.
For myself, I would think going into this with the right mindset, the right emotional and intelligent and emotional maturity of the situation, and approaching it not so much emotionally, but logically, even though it is an emotional subject.
Yeah, exactly. Well, thank you all for listening today, and we look forward to talking to you in our next podcast. And if you'd like to check us out and find more out about the firm, go to www.allfamilylaw.com. Thanks.